Hello and welcome to this Gowling WLG TUPE Club webinar on TUPE in the real estate sector. I'm Siobhan Bishop from the Employment, Labour and Equalities team, and I'm joined by Jane Fielding, who is a partner in our team, and Rebecca Jones, a principal associate. And they both have experience in this specialist sector of advising in the real estate sector. So moving on to the first scenario, Rebecca is going to look up what is TUPE.
That's right. So before we get stuck into the nitty-gritty of TUPE in the range of real estate situations, I thought it would be helpful to get you warmed up with a quick overview of what is TUPE and what TUPE does. So first of all, what is TUPE? Well, TUPE stands for the Transfer of Undertakings Protection of Employment Regulations 2006. And I've just underlined the protection of employment bit there because this is what TUPE is all about, the key policy underlying it. And how the courts will interpret it, they will come at it from the perspective that this is about protection of employment. So the key principle is that a change of ownership or responsibility for work should not interrupt employees' rights. Employees follow the work or the activity, and there is no need for a contract between the transferor and the transferee, and those are the terms that we give to the parties in the transaction. We'll come on to talk about the different types of transfer, but I just want to highlight that point, that there's no need for a contract between the two parties. The important thing is to look at the start and end point of where the work is moving to and from to identify whether a transfer has taken place. On the next few slides, we're going to look at the key functions of TUPE. So what does it do and why is it something that we need to cater for in a real estate situation? So first of all, it preserves and protects employees so that their employment is not disrupted by the transfer. And specifically looking at those protections, first protection to mention is that employees transfer to the new entity responsible for the business or the service delivery. That's an automatic transfer of their employment. They transfer on their existing terms and conditions of employment, so they are entitled to the same pay and the same contractual benefits after the transfer as they enjoyed before. It also preserves and protects claims against the previous employer, which transfer with the employees, and that's very important in terms of the parties' contractual arrangements. The new employer steps into the shoes of the old employer, so if there are any claims or any unpaid wages or other issues, this all becomes the responsibility of the new employer. In short, the new employer becomes responsible for anything that happened on the old employer's watch. And for this reason, the parties to a transfer will usually look to apportion liability pre- and post-transfer. And the final protection to mention there is that collective agreements and trade union recognition will also transfer. So we've looked at the things which are preserved by TUPE, and building on that, there are also certain obligations and enhanced protections for employers to be aware of. The first of these is that the outgoing employer has an obligation to provide workforce employee liability information, and that's information that has to be provided 28 days before the transfer. It can be helpful in situations where there's no direct contractual relationship between the parties, but generally it's seen as too little too late, and we'll come on to look at that in a little more detail later. The second obligation is the duty to inform and consult with representatives. Consultation should be carried out with employee representatives in good time before the transfer. There's no fixed time period, but what is in good time really depends on the impact of the transfer for the individuals. And if everything is straightforward, then we'd expect a period of around 2 to 4 weeks to be sufficient. So moving on to look at the increased protections that TUPE offers. There are 2 points to mention there. Firstly, it's more difficult to change terms and conditions of employment. So we saw that employees transfer on their existing terms and conditions, and it's quite common for the new employer to want to harmonise those terms with its existing workforce. But TUPE actually provides employees with protection against changes, which makes that much more difficult. That's not to say that it doesn't happen, but it's something that employers have to plan and cost for. The second point is the increased protection against unfair dismissal. So similarly, dismissing employees is more difficult if the transfer is the reason for the dismissals. The new employer can't simply replace the old workforce with its own people. And again, workforce changes are something it's necessary to think about and plan for. Importantly, the 2-year qualifying service requirement does still apply for unfair dismissal claims. So if you've got individuals that have less than 2 years service, then there is a little bit more flexibility there. And the final point to note there is that if employees are dismissed by the existing employer before a transfer, then that liability is something which transfers to the buyer. The buyer will become liable for it. So it's something that the buyer needs to factor in when looking at a TUPE scenario.
Thank you, Rebecca, for setting the scene for us there with the legal background. And next we'll turn to the big question, will TUPE apply? So Jane, when will TUPE apply?
Yeah, that's the million-dollar question. And we spend a lot of time helping clients try to identify that or gauge the risk of it applying. But I'll say up front, there's not always 100% certainty of that. So sometimes we just have to take a view and proceed on the basis that it will or it won't. But that's not necessarily always without risk. So there are 2 tests which are on the slide there that you have to look at to see whether TUPE applies. The first one is where there is a business transfer, and that's been with us since TUPE first came in 1981, and that's where there's the transfer of an economic entity which retains its identity after the transfer. And the second test is one that came in 2006, largely to address the fact that the old test had started being applied as a matter of case law to outsourcings. And so this service provision change test was brought in to try and give some greater certainty in outsourcing situations. So this is where activities which are carried out by or on behalf of the client are carried out by a different party after the transfer from the party that did them before. And in every scenario, you need to consider both tests because they are not mutually exclusive. So just because something doesn't meet the service provision change test, it could still be a business transfer, so you need to consider both. So looking at each of those in turn, and the business transfer one first, as I mentioned, there needs to be the transfer of an economic entity that retains its identity. And that's expanded a little bit in the TUPE regulations to say there needs to be an organised grouping of resources pursuing an economic activity. And it doesn't matter whether that economic activity is ancillary or central to the business, but it needs to be identifiable in and of itself. So the sort of classic business transfer situation is in an M&A context, where a business is sold as a going concern. But if you look at that in a real estate context, that could be the commercial property sale of a hotel or a retail park, where the buyer, the new owner, is going to be continuing the same business from that property. So they will be the transferee in TUPE language. We often get asked, well, the plan is to have a temporary closure of the property while we do a refurbishment. Does that defeat TUPE? And if so, how long do we have to close it for? And the answer to that is not in and of itself. So it depends on the factual scenario in a particular situation, but a temporary closure for a refurbishment, so the property may still going to be operated as a restaurant, but there's just a bit of a overhaul of the decor, and it's closed for a month or so, that's not going to stop TUPE applying. Or it might be a slightly longer period that it's closed for to perhaps get a new licence for the premises if it's a pub, and that takes a bit longer than anticipated. If it's still going to operate as a pub afterwards, even a slightly longer one won't stop TUPE applying. So it's going to be fact specific, but it's not a get out of TUPE card just to close it down for a while. And also in a real estate context, it could apply, and we'll look at this in a little bit more detail later, where there's the grant or termination of a lease or the assignment of a lease. For example, if there's a multi-tenanted property like a shopping centre and one of the outlets changes hands in terms of leaseholder, that could also trigger a TUPE transfer. So turning to the service provision change, as I mentioned, this was largely brought in to address outsourcing situations. And so it applies where activities are being carried out by a client on its own behalf, and they decide to get a contractor to do those services for them, those activities. So first generation outsourcing. But it can also apply where the client has decided to change contractor, to switch to a different provider, so second generation outsourcing, and also where the client decides actually they now want to do that activity back in-house and they insource it. So in all of those scenarios, we might be looking at a service provision change. And again, putting that into the real estate context, what we're thinking about here most commonly is things like property managers who might be providing property or asset management services, potentially on-site and also back at their own offices off-site. There could be cleaners, security guards who are attached to the building in question, performing those services, and they might be employed by the owner of the building or by an FM provider. So there's all sorts of scenarios that a TUPE could apply to. So for there to be a service provision change, various conditions have to be met. There's quite a specific definition in TUPE. But one of the key ones is that the activities before and after the transfer have to be fundamentally the same. And another important one, which has sort of emerged from case law in terms of how it's defined, is that there needs to be an organised grouping of employees in Great Britain whose principal purpose is carrying out the activities on behalf of the client. And each element of that definition is important. So it could be that there is a property management company in place, and the way it organises itself is that no individual employee is assigned to any particular client. Everybody services everyone. So that would mean that there wouldn't be a service provision change because there wouldn't be an organised grouping of employees assigned to a particular client. The other thing that's important to remember, particularly in a real estate context where there might be several chains of subcontracting, is that TUPE specifically says that a contractor includes a subcontractor. So you need to think in any sort of situation whether there are TUPE transfers between contractors or subcontractors, and we'll have a look at that in a little bit more detail later. And finally, there's a principle that has emerged from a real estate case that, although it talks in TUPE about the client, that actually if there is more than one client, a grouping of clients, then there still can be a service provision change. So this principle came out of a case where there were residence management companies on a residential estate, and they grouped together to commission services for the estate jointly. And when they changed provider, because they had a common intention to commission those services jointly still before and after, and they were after the same scope of services, the fact there were more than one client didn't defeat TUPE applying as a service provision change.
Thank you very much, Jane. And I think, as we've seen from what you've said, the legal tests themselves are, in a sense, quite formulaic, and where the real difficulty and the real skill comes in to it is when you're applying those tests to a real-life situation and looking at the actual facts. And Rebecca and Jane are both going to deal with some of those. And so I think we'll start off with Jane looking at the first of those situations.
Yes, so we're going to look first at buying or selling a property, and there's quite a busy diagram on the next slide to illustrate the fact that there could be multiple TUPE transfers if you're looking at a situation where there is a property which is part of with a business being operated from it, and the property is sort of transferred as part of that business transfer, where the business is sold as a going concern. So that's why it says TUPE question mark at the top, where you've got the sale between the seller and the buyer. If that business with the property in it is actually being sold not as a going concern, but it changes hands by way of a share transfer of the shares of the owner, then TUPE doesn't apply. So it's important to understand what type of sale you're dealing with. Is it an asset sale or a share sale? But assuming for these purposes that it's an asset sale, there could be a TUPE transfer at that level. And then we need also to think about whether there is a change in property manager managing that property. There could be a TUPE transfer there. And then one level down, there could be a main FM contractor, so the pink bubble. It may be that the buyer continues with the same contractor, in which case there wouldn't be a TUPE transfer, or it may be that they change, in which case there might, under the service provision change, most likely. And then, as I mentioned earlier, TUPE specifically says subcontractors are also counted as contractors. So it may be that the main FM contractor has subcontracted certain services. It could be, for example, they do general cleaning of the building, but every so often there's a deep clean or a pest control thing that comes in, and that is subcontracted to specialist subcontractors. So at all those different levels, there could be TUPE transfers that you need to be thinking about. So the most common scenario that we deal with is sale of a commercial property. It could be the sale of a hotel, it could be retirement homes, shopping centre, something like that. And we always need to find out, when we're considering whether TUPE is going to apply, whether the building is going to be sold with vacant possession, and if so, what is going to be happening eventually in the long term. So if it's being closed just for refurbishment, we've already talked about the fact that that doesn't necessarily stop TUPE applying. But if it's being sold with vacant possession because it's going to be redeveloped and it's going to be used for something very different once it is occupied again, then it may be that it simply doesn't retain its identity, and therefore it doesn't meet that business transfer test, which we talked about right at the beginning. So, for example, it might be that somebody is buying up a former day school where pupils came and went, and the rooms were configured as classrooms, and that's going to be sold with vacant possession and turned into retirement flats. So it's going to be residential and a completely different use. In that circumstance, it clearly wouldn't retain its identity and TUPE wouldn't apply. We also need to think about whether there are existing leases in the property. And if there are businesses that tenants who have those leases are running, and the intention is that once the building has been sold, those tenants will carry on running their businesses, then the employees of those tenants will simply carry on being employed in those businesses, and TUPE won't be relevant. But we need to think about associated transfers. So as we saw from the diagram earlier, are there property managers, providers of facilities services like cleaning, security guards, etc., who we need to think about, and whether or not there's a TUPE transfer there that we need to take into account. And it's not just where buildings are sold that we need to think about TUPE. It could be that the building is staying in the same hands, but the owner or the property manager on their behalf has decided that actually they need to have a change of services. And the first thing, obviously, the owner might simply decide to change the property manager. So does TUPE apply there? Well, possibly. As ever with TUPE, it's going to be fact specific. So the first thing to think about is, well, what services is the property manager actually providing? Because for there to be a service provision change, as we saw earlier, the services that the new property manager will provide need to be fundamentally the same as those that the outgoing property manager did. And it may be that the scope is sufficiently different for that not to happen. And we also need to think about whether there is that organised grouping of employees. So depending on how the current property manager has configured its workforce, it may be, if there's nobody dedicated to the particular property's work, that actually the service provision change will be defeated. And we need to think also about other subcontractors. So often the property manager will simply act as an agent and commission the facilities management services on behalf of the client. So if the property manager changes, that shouldn't disrupt that relationship, because the contract will be between the owner and the facilities manager provider as a subcontractor. But that's not always the case, so we always need to double check that just to make sure that there isn't a TUPE transfer at that level as well. So just picturing that as a diagram, it's a fairly simple one. You have the client at the top, they've got their existing property manager, they decide to change and they appoint the new property manager. The TUPE will be between the existing manager and the new one. So there's no contract between them, but because of their respective contracts with the client, TUPE will operate at that level. There's no sort of bounce back up to the client and out again. It's between the existing and the new property manager providers.
Okay, so we've looked at the sale of a property and we've looked at service provision changes for a property manager and other contractors that are involved. And on the next few slides, I wanted to explore what happens when we bring the two of those things together. So we have a property sale involving simultaneous change of owners and contractors. Does TUPE apply? And if I turn to the next slide, we can have a look at that in more detail. So on this slide, we can see there are two different transfers happening. Firstly, at the top level, we've got a change in the owner of the property. It's moving from client A to client B, and as Jane explained, that could involve a TUPE transfer of employees who are engaged by the owner if the necessary requirements are met. When we move down a level, things get a little bit more complicated. Jane took us through TUPE and how it applies on a service provision change, but importantly, for a service provision change to occur, there must be a single client for whom the service is provided. And what this diagram shows is that the identity of the client is changing at the same time as the identity of the service provider. The owner is selling the property and all of its contractors stop providing services on completion of that sale, and the new owner then brings in its own contractors. So to look at this in more detail, it's known as a Hunter and McCarrick situation after the case that first considered this issue. After several appeal stages, the case was actually decided as McCarrick and Hunter, but that doesn't slip off the tongue quite so easily, so we're going to go with Hunter and McCarrick. So let's have a look at what Hunter and McCarrick says and what it means in practice. So on the face of it, Hunter and McCarrick might provide a useful exception to the usual TUPE position. There's no service provision change where there is a change of client at the same time as the change of service provider, which means that a buyer who's buying that property might have more flexibility if it wants to change contractors and bring in its own people when it completes on the purchase of the property. It's important to remember at this point that TUPE is mainly an issue for the buyer because the effect of TUPE is to make the buyer responsible for employees and liable for pre-transfer liabilities and on the hook for dismissals in connection with the transfer if the seller's employees do transfer to it, or if the contractor employees transfer to its contractors. So the buyer may well find that protection very helpful in the Hunter and McCarrick exception because it doesn't have those normal worries. And where there is no transfer, the redundancy and the employment costs will remain a matter for the seller and its contractors. If there's no transfer, then the employees will either need to be redeployed or made redundant by the seller and its contractors. And there's a question as to whose issue this is going to be between the seller and its own contractors. So the redundancy and employment costs are likely to be incurred by the seller's contractors rather than by the seller itself because it's the contractors that actually employ the individuals. But what we're finding in real estate scenarios is that it's becoming more and more common for contractors to make sure they've got indemnities that protect themselves against that and push that cost back up to the seller if it is incurred. So looking at the detail of Hunter and McCarrick to decide whether this exception applies, it's necessary to consider the tracting position at each level of the chain. And when we're looking at this, I find that the best thing to do is to go back to the drawing board, and I mean that quite literally. So what we want to do is to sketch out a diagram which shows the position before and after the transfer. On the left-hand side of the page, we've got the seller, and below that, its contractors and any subcontractors that are providing services in connection with the property, with a note indicating where the employees sit. Then on the right-hand side of the page, we want to sketch out the buyer and its intended structure after completion. And what we're looking to do is to draw a dotted line down the middle of the page that shows completion with all of the changes happening at that same point in time. We've then got a big tick against the first 2 points on this slide. So we've got a change in the managing agent and the suppliers, and we have a change in the client at the same time. So everything changes on completion. And if we've got those ticks, then we have the Hunter and McCarrick exception, which means that there can't be a service provision change. However, moving on to point 3 on that slide, could there still be a Regulations 3.1a business transfer. This is a significant caveat to the Hunter and McCarrick position. And what that means is that Hunter and McCarrick says that there will not be a service provision change in this scenario, but what it doesn't consider is whether there could be a TUPE transfer as a business transfer. And if we go back to Jane's section right at the beginning, once we've decided that there is no service provision change, we've also got to consider whether the service could amount to an economic entity in itself. And with most of these services, we're looking at labour-intensive arrangements, which could be more difficult to judge because there aren't a large number of assets for us to look at to decide whether there is a going concern transferring. So if we take security, for example, we're looking at the security guards, taking them out of the equation and for a moment, and looking at what else is needed in connection with that service. So looking at things like CCTV, if there's a security office, radios, those sorts of things that are used for the security provision. And it's necessary to have a think about who owns all of that kit and what's going to happen with it. And if the buyer ends up with the use of that after the transfer or after the sale, then it's more likely that there's going to be an economic entity which is the security provision which has transferred. So it's important always to think about whether there could be a business transfer even if there isn't a service provision change. And it's also important to remember that it's the buyer that's going to take the risk of any uncertainty. So unless the buyer can obtain an indemnity from the seller, and we'll come on to look at contractual protections toward the end of the session, then it's the buyer that potentially has that risk. So I think one question that it's worth asking early on is, where does the buyer want to get to and why? And what we've seen in the service industry over the years is that the parties will often agree to proceed on the basis that TUPE applies if there's any uncertainty. Remembering that it's about employment protection, so there's a good chance that the tribunals, if there's any uncertainty, will come down on the side of TUPE applying. And it's worth considering, if the seller has security before the sale and the buyer is still going to need security, then quite often the easiest approach is just to proceed on the basis that TUPE applies. And generally, that's going to be fine. The employees themselves aren't going to take any issue with it. But having said that, there might be very good reasons why that doesn't work in a given situation. So the best advice that I can give is for the buyer to think about it early on. Think about whether Hunter and McCarrick might apply, whether there's any uncertainty there, decide where they want to get to, and then we can be clear about where the potential risk and cost might be lurking. And it's easier to try and negotiate a commercial solution. So the next scenario that I wanted to have a look at is facilities and maintenance contracts and how we approach those in a sale situation. We're going to focus on contracting for TUPE in more detail toward the end of this session, but as a sneak preview, when we're looking at TUPE clauses in a maintenance contract, what we want to see is that there's a set of clauses that apportion liability in relation to the transfer on commencement of a contract, and a set of clauses that apportion liability for transfers when the contract ends. So in this scenario, we have our seller who has appointed its contractors. The buyer plans to stick with those contractors when it completes on the sale, but when it looks at the contract that the seller has negotiated with its contractors, it finds that TUPE has been forgotten. So what's the impact of this, and what can the buyer do? Well, let's take a look at that in stages. So we have our seller who's negotiated a contract with its contractor that has poor TUPE terms, TUPE protection in there. And we have the buyer who's looking to retain those contractors. The buyer's got two choices. First, it can take an assignment of the contract. What happens there is that the buyer takes on the contract and it finds itself with the same poor contract terms in respect of TUPE. The second option is that the buyer can take a novation of the contract. Now this gives it the opportunity to secure more adequate TUPE protection. So if the buyer is talking to the contractors about staying in place after the completion of the sale, it might have an opportunity to agree to renegotiate the contract to address any poor contract terms and make sure that it's got adequate protection in place. And the reason that it wants to do this is because if it seeks to change the contractor and appoint a new contractor after completion of the sale, then TUPE is likely to apply at that time. So TUPE is going to apply to transfer the staff of the existing contractor to the buyer's new contractors. And when that contractor is coming in, it's going to look to the buyer to make sure that it has indemnities and contractual protection, protecting it against any historic liabilities or any risk that the employees bring with it. In the first situation, if the new contractor is taking over a contract that the buyer has on poor TUPE terms, the buyer isn't able to go to the current contractor and to back off any indemnities that the new contractor seeks from the buyer. So the buyer's taken over that contract from the seller and it's left with the same poor contracting position. And what that's likely to mean is that the new contractor will price for that uncertainty because it's not getting the indemnities, which means that the buyer then ends up having to procure the services at a higher cost than it would otherwise. If we have a look at the scenario then where the buyer has novated the contract and been able to secure better contract terms, the buyer's then in a position where it can say to the new contractor, I can tell you exactly who you're getting and I can give you protection against anything that the individuals might be bringing across with them. I can make sure that you've got protection against consultation process and the various obligations that occur in relation to the transfer process. And in that scenario, the buyer is then able to back off anything that it's agreed to provide to its new contractors, and it's been able to then retender the services at the most effective contract price.
Thanks, Becky. So I'm going to look briefly at the situation with leases. So where a lease is granted or assigned to a new tenant, we also need to be thinking about whether TUPE applies. And that could be because the landlord forfeits the lease or operates a break clause, or where the landlord accepts a surrender from a tenant. In all those scenarios, TUPE could apply depending on the facts. And on the next slide, there's a diagram of how that would work. So the landlord has given the lease to the existing outgoing tenant. Somehow, in one of those three ways, the lease comes to an end, and the landlord grants a new lease to the incoming tenant. If TUPE applies, it will apply between the outgoing tenant and the incoming tenant. Again, there won't be any bounce back to the landlord and then a bounce out again of staff to the new tenant. It's simply directly from one tenant to the other. And again, as we saw with the providers, there won't be any sort of contractual agreement between those two tenants. So they will both be looking to the landlord for any contractual protection that they have. So moving on to the next slide, the employees of an existing tenant may transfer to the new tenant if the same business is going to be operated from the property by the new tenant. So it could be that it's a pub and one tenant is giving up that pub and a new one is coming in. The staff may transfer. Or it could be that there are services attached to the building, so cleaning, security, etc., as we've talked about. There might be a TUPE transfer there. But what happens where the old tenant is operating a different sort of business? So you'll see on the slide there are some scenarios. So if the old tenant's operating a DIY store and the new tenant's going to be operating a restaurant, that's clearly going to be a very different business. And TUPE is not going to apply to the employees employed in that business. There might be ancillary services attached to the property, such as cleaning or security, which might transfer, but the employees in the core business won't, because it's not a business that retains its identity after the building is given to a new tenant. Conversely, if the new tenant is going to be operating a DIY store as well, then clearly that's going to be the same sort of business, same identity. TUPE applies. And then the third one is the maybe option. A flat pack furniture retailer moves in. Is that sufficiently close to being DIY? Because although you buy the furniture as a product, you then got to assemble it. Is that sufficient for DIY? That's one where you would have to dig a bit deeper to look at that, but that's a maybe one for TUPE applying. So as you can see from those different scenarios, the key is, does the business or the way the building is being used by the new tenant mean that it's retained its identity? And that's going to be a question of fact in each case. you need to think about, even if it doesn't retain its identity, whether there are ancillary services delivered to the building which might trigger a TUPE transfer. And we also need to think about what happens if there is no new lease. It could be that the landlord decides to take the business over themselves, and in that situation there could be a TUPE transfer of the business to the landlord. It could be that the landlord decides to take on provision of the services that are delivered to that building directly. Again, that could be a TUPE transfer. But if there's no new lease because the building is going to be completely redeveloped and it's going to be used for something different in the future, then that is likely to defeat TUPE, because it won't be the same business being carried on. It won't retain its identity. And if it's a temporary refurb that it's and there's no lease granted at that point, but there's going to be one granted in the future, then we need to look at how long that's for, what the purpose of it is, and is the business, once it starts operating again from that premises, is it going to be the same as before? So all those points we made earlier about temporary cessation of business, temporary vacation of the...
But what I want to do next is to drill down in a bit more detail to another key practical issue, which is about employees. Who will actually be caught by TUPE? Of course, sometimes in a deal there may not be many employees who are actually impacted or who are on the ground and who might be caught by TUPE, and there's a real risk that they can be overlooked until quite late in the process. So let's spend some time on looking at which employees are in scope, and Jane is going to look at who is assigned.
Yes, so this is often quite a big area of contention, particularly if the transferor is struggling financially or they don't have new work to redeploy employees onto. We quite often see people trying to put more staff onto services than one might think the service required or needed. So we're talking about employees of the transferor, and if we're talking about a business transfer, we're talking about employees who are assigned to that organised grouping of resources, which is part of the business transfer definition. And if we're looking at a service provision change, then they've got to be assigned to the organised grouping of employees. And although you might think, isn't that the same thing in a service provision change, it is actually two parts. It's a two-part test. So you have to look first at, is there an organised grouping of employees, because it's got to be a conscious organisation of staff. And then as a second question, for each individual employee in the mix, you have to look at whether they are assigned to that organised grouping. And obviously there's a great degree of overlap, but they are two separate questions. And assignment is going to be very fact-specific, but what we do know is that somebody's got to be assigned other than on a temporary basis. So we're looking at things like, are they just there as temporary cover? Are they there as cover for someone who's off sick for a short period of time? Or have they recently arrived at the building, but actually it's a permanent transfer to that place, or it's envisaged to be? And we have to look at all the factors. None of them is determinative in and of themselves. And on this slide, we've listed out the various factors that are most commonly considered. And at the top, we've got time. And I'm just going to do a bit of a myth buster here. We often get asked, well, it's 50%, more than 50% means somebody's assigned for TUPE purposes, doesn't it? No, it doesn't. It's often a starting point as to sort of identify the people most likely to be in scope, but it isn't simply a question of how much of their time they spend on the particular business or service that is in question. So it's a factor, but it's not a determinative factor. We also need to think about things like the nature of the work. What does it say in their employment contract? If it says your job is to be the on-site property manager at this shopping centre, then that is going to be quite a strong pointer to assignment. But if that's actually not what they're doing in practice, because things have moved on since the contract was drafted, then we may need to look at that more closely. Look at their actual responsibilities of what they're actually doing. Allocation of cost is an interesting one. Often in a real estate scenario, if the cost is being recovered via the service charge for a particular property and it's all of the cost, then again that's a strong indicator of assignment. And then the last one we look at, sometimes it's a little bit subjective, but what's the value of that individual to the service or the property in question? So is there somebody who is, been there, got a particular knowledge of that building, even if they can be moved to other places, actually their knowledge of that particular building is vital. It's things like that we're looking at. So in a property sale, we need to be thinking about whether there are employees who might be direct employees of the seller. They might be involved in running the business that's operating from the property, or they might actually be employed facilities people in the actual building. It's just that the seller employs them directly rather than contracting out. We need to think about property manager employees who are responsible for the building, and they could be off-site, or they could be in a large enough property where perhaps it's multi-tenanted and there's a lot of property management to be done. They might actually be embedded in the property in question in an office of the property manager. So we also need to think about employees of any tenants who are running businesses from the property in question, and whether or not they are going to be assigned. And then, of course, they also may have subcontractors. So we need to think about all those people who might be in the mix. But as with whether TUPE applies or not in the first place, there are grey areas with who is assigned. And these often arise where there is a part transfer. So there might be a portfolio of properties, or it could be one property that's split up into different leases, and that portfolio is being split. So then we have to think about, well, depending on which properties are being split out, which employees are assigned to those, and maybe there aren't anyone assigned. Maybe it just hasn't been set up that way. We need to think about the impact of that splitting on any employees back at head office. If the property managers organise themselves so that they do have people dedicated to particular properties, is the fact the portfolio is being split, is that going to impact on that? Is anybody assigned, or is the property manager going to be left with a redundancy situation because no one is assigned but they don't have as much work? That cannot play out in terms of support functions. So there could be marketing, sales functions. If it's a new development and there's a lot of activity in assigning or selling the properties and getting leases on properties, it could be there's a particularly busy time on that site, on a particular site, at a particular point in time, but that's not going to be ongoing activity, and that could also affect whether someone's assigned or not. People's work may be spread across different properties, and there could be shared services where there are teams supporting a number of properties. So a bit like back at the head office for the property manager, if people are not organised in a way that is assigned to the properties that are splitting off, then again, whoever employs those individuals might be left with a redundancy scenario.
Thank you, Jane. As we can see, there are often quite a lot of questions you need to look into in a great deal of detail before establishing or taking a good guess at whether or not somebody is assigned and coming to a conclusion on that. But next we're going to look at a high level, really, what the obligations of TUPE are on each party. And Rebecca will overview the main issues, and if you would like more information on any of those, for example, the information and consultation process, there are other webinars available on our website where you can get more information. But Rebecca, what are the main obligations the parties need to consider?
Well, Siobhan, in this next section, I wanted to explore the key TUPE obligations that the parties have in a scenario where TUPE applies. And we're looking at this, firstly, from the point of view of the current employer, also known as the transferor. So that's going to be a seller in a sale scenario, or the outgoing contractor in a service provision change scenario. And as the current employer, the seller or the outgoing contractor has obligations under TUPE, which are set out on that slide. Firstly, to provide employee liability information. We touched on this earlier, but essentially it's an obligation to provide information about terms and conditions of employment, about grievances, disciplinaries, and claims that have arisen in the recent past. And as I think I mentioned earlier, it's generally seen as too little too late, but it is an obligation there under TUPE that the seller or the outgoing contractor needs to comply with. Secondly, there's an obligation to inform and consult. Now, the obligation to inform and consult is mainly a matter for the outgoing employer, and they have an obligation to inform and in most cases consult with employee representatives. The new employer has a duty to provide information about measures which it proposes to take in relation to the transfer, and we'll come on to that when we look at the obligations on the new employer. But it has to provide that information to the existing employer for the consultation process to play out. And it's a good idea for the seller or the outgoing contractor to request that information in preparation for the consultation to begin. We talked earlier about the timing of that process. And as I said, it can generally be completed in a period of around 2 to 4 weeks if there's nothing significant that's going to change. It's worth bearing in mind that if there are no existing employee representatives or trade unions in place, then time needs to be built into the process to allow for that to happen. And then the final bullet point on the slide is to think about the contractual obligations. So as well as the obligations that the seller finds itself under TUPE, it's important to check whether it's got any contractual obligations. This is most likely going to be relevant for an outgoing contractor, but that contractor needs to have a look and see whether they've agreed to provide any information about employees at any specific time, whether there's any restrictions on what they can do with employees in the period leading up to the termination of a contract, which might trigger a transfer. And also it's possible that there might be some general cooperation provision that requires them to cooperate with the new employer to enable the transfers to run smoothly. Moving on, as well as the statutory and contractual obligations, there are various steps that the seller or the outgoing contractor should take to protect itself in more commercial terms. And firstly, looking at workforce planning, it's important for the seller to consider what it wants to happen versus what's going to happen under TUPE versus what the buyer wants to happen. And it's then possible for the parties to identify any mismatch and start to think about how contractually or commercially that can be dealt with. For example, if we've got a scenario where TUPE applies, the seller should have a think about whether it's comfortable with its employees going across. Are there any star performers that it wants to keep? And if so, it needs to have a look about whether there's any contractual restrictions that would prevent it from doing that. And what if there's a Hunter and McCarrick argument? Is the seller prepared to incur redundancy costs, implementing redundancies because the individuals won't transfer? What if the buyer wants an indemnity against the uncertainty of TUPE applying in that scenario? So generally, what we say is that the sooner a party is clear about its position, then the stronger their negotiating position is going to be when they go and ask for cover for those uncertainties and those risks or those costs from the other party. So having done that workforce planning, where there's a mismatch between what the parties want and what will happen under TUPE, it's worth assessing the potential cost early on. And what we're basically looking at there is redundancy costs, the cost of notice pay, and possibly unfair dismissal claims, and possibly consultation claims. But often, if it's a situation where there's only a handful of employees involved, then that might actually be an insignificant figure compared to the wider deal costs. So it's worth looking at that early on and coming to some sort of agreement as to how that's going to be apportioned and who will carry that cost. So moving on from the seller side to the buyer side, so we're looking at a buyer in a sales scenario or an incoming contractor in a service provision change, essentially the new employer. The first thing to do again is to carry out due diligence. So if this is a situation where TUPE might apply, ask for employee information from the seller or the outgoing contractor to understand who's doing what, where those employees sit, who employs them, so that a TUPE analysis can be carried out. Compare what's currently happening to what the buyer intends will happen, and identify any areas of risk for which the buyer might want to seek protection from the seller. And as an example, if the buyer is buying a property where there are cleaners engaged by a subcontractor who is going to be replaced, the buyer might identify that there's a Hunter and McCarrick argument, but it would be wise to be clear to the seller that they require an indemnity to protect itself against the uncertainty that's associated with that argument. And the earlier that is put on the table, the more likely that they're going to find that the seller will agree. And as with the seller, the buyer is subject to some obligations under TUPE. So first, to provide measures information. And that's information about any changes which will occur for the employees as a result of the transfer, essentially. So that could be something fairly minor, like a change in healthcare provider for private healthcare benefit. It could be a shifting of pay dates, or a change in the holiday year, or it could be something much more significant like redundancies and relocations. The buyer or the new employer needs to work out what those issues are and make sure that it's notified them as measures information to the seller, so that the seller or the outgoing employer can then carry out the consultation process about that. It's possible, although also relatively rare, that the buyer could have an obligation to consult with its own employees, and that's where the buyer has employees that are going to be affected by the transfer. So if, for example, the buyer has individuals that are that are carrying out functions that the seller's employees are doing when they come across, and there could be a resulting redundancy situation, then potentially the buyer could be subject to an obligation to inform and consult as well as the seller. And another key consideration for a buyer where TUPE will apply is to ensure that it thinks about and negotiates adequate contractual protection for itself. So we're going to look at contracting for TUPE in a bit more detail in the next section, but remember that the buyer or the new contractor is going to inherit any existing liability, and so it will need to negotiate contractual cover with the seller or the outgoing employer where it can to apportion that. An added consideration in a service change scenario is that TUPE might apply both at the start and the end of the contract, and so a contractor needs to be thinking ahead as well as planning for the present and looking at exit at the same time. And in particular, given the risk of a Hunter and McCarrick argument, the contractor would be well advised to try and negotiate protection against redundancy costs if TUPE doesn't apply and it is left with staff at the end of a contract.
Thank you, Becky, and thanks for highlighting the importance of a contract in a TUPE scenario. And indeed, that's what we're turning to next. So how the contract can be used in a TUPE scenario to help mitigate those risks and manage the process smoothly. And of course, how the allocation of liabilities reflects the commercial strength of the parties in reality. Plus, detailing your particular requirements, so tailoring particular clauses to the specific circumstances in this deal. So, Jane, what do you need to keep in mind on the sale or the commencement of services?
So, where you've got a sale, a one-off sale, which is most likely to be a business transfer, or the commencement of new services under a service provision change, if you're the seller or the client, then you need to think about what protection you have if you have an incumbent provider in terms of the services about employee matters, because as Rebecca talked about earlier, what we're looking for is, whether the seller has got protection backed off that they can pass on to a new provider if we're in a service provision scenario, or obviously if they're just selling and there isn't a contract in place, it may be that it's depending on the risk that they are prepared to take in terms of what liabilities they know about, because it's their own employees. So we need to know, to gauge that risk and to look for where the back protection might be, is, are the employees transferring from the client or an existing contractor? And if they are transferring from that existing contractor, we need to have a look at the contract, ideally with that contractor, to look at what protections the seller has. So we're really looking for the sort of the gap in that exposure, and we're trying to gauge the risk commercially. So if actually, because of the nature of the deal, there's one security guard potentially in the mix, and that person's got less than 2 years service, as Becky said, you still need 2 years service for normal unfair dismissal. So actually the risk profile of dismissing that person, that one individual with their short service, is probably not that costly, depending on obviously the value of the overall transaction. That's going to be a very different risk profile from where you've got a large shopping centre with lots of different FM staff assigned and they've got long service. In that situation, you're going to be much more concerned if you are the client and you've got a poor TUPE protection in your existing contract with the current contractor, because your exposure might be considerably bigger. So turning to, if you are the buyer or the incoming contractor, you're going to be looking to the seller or the client for that protection. And the type of protection you're going to be looking for by way of indemnities is a number of things. So you're going to be looking for any failure, indemnities for any failure by the seller or the current contractor to carry out the information and consultation exercise, which Becky talked about properly. You know, the primary people to be informed and consulted are going to be the employees of the seller, client, or any existing contractors. And so as the incoming employer, you're going to want to know that's done properly, because if it isn't, you're going to inherit those liabilities. The second indemnity you're going to be looking for, given that TUPE effectively transfers the staff with all of their baggage, if I can put it that way, any pre-transfer liabilities, any claims they've got, you're going to be looking for an indemnity for that. You don't want to be carrying the can for that or paying the expense of it as the buyer. The third one is going to be an indemnity for any failure on the part of the seller or client in giving the employee liability information, which we talked about earlier. So if that's not accurate, and therefore you incur liabilities that you hadn't planned for, you're going to want to have that indemnified. And then finally, what we normally see in a TUPE scenario is a list of people in scope to transfer, and that's a defined list. And then we'll have an indemnity for people who are not on that list, who are described as unexpected transferring employees. So, you know, the seller controls the list. They ought to know who should be in scope, ideally, but if there's a long subcontracting chain, they may not. And this unexpected transferring employee indemnity gives the buyer security that if that list is wrong and other people turn up on day one and say, well, actually, I have now TUPE transferred, there is a mechanism there in the indemnity for them to dismiss those people within a time frame and be able to call on the indemnity. And that's usually quite heavily negotiated in terms of carving out liabilities that the buyer or the incoming contractor causes in the way they handle those people. So, you know, the seller probably wouldn't agree to be on the hook for discrimination claims if the buyer or the new contractor could have avoided that. If we are looking at this from the perspective of the seller or the client, though, they're also going to be looking for indemnity protection from the buyer or the new contractor, and their concerns are going to be similar but slightly different. So the first type of claim they're going to want to be indemnified for are Regulation 4.9 and Regulation 4.11 claims. So these are claims where, although the liability is triggered by something that the buyer or the new contractor does or proposes, if the employees object to transferring to the buyer or the new contractor, those liabilities will stay with the seller. So although it's nothing caused by the seller or the old contractor, the liability will stay with them. So they're obviously going to want an indemnity for that. And the types of liabilities we're talking about are, as it says on the slide there, under Regulation 4.9, they're proposals to make a substantial change in the working conditions to the employee's material detriment. So that could be changing pay rates, changing hours, changing location. And more seriously, acts or proposals to carry out a repudiatory breach of contract. So that could be, you know, making changes to pay with no proper process or something like that. Similar to the concerns that the buyer will have, the seller or the client will want to be indemnified for the buyer or the new contractor's failure to comply with the consultation requirements, and that would really be not giving measures information to the seller. That's the extent of their obligation, really. And they're also going to want to know that from the point that the transfer takes place and beyond, any employment liabilities or dismissals are going to be on the account of the buyer or the new contractor, subject to that unexpected transferring employees indemnity that we talked about. So they'll want a kind of clean slate going forward. Sometimes, though, there are a bit more complicated issues to think about, and we have bespoke clauses that are drafted. So we might be wanting to contract for the Hunter and McCarrick uncertainty that Rebecca's talked about. We might, even if a service provision change isn't there, we might want to be being clear that we still think it applies because there's a business transfer. It may be that there are redundancies and the parties have reached a commercial agreement to split the cost of those redundancies, That might be on a capped basis, or it might just be limited to enhanced payments, but not statutory redundancy payments. So there might be bespoke drafting around that. There might be requirements allied to the fact that there might otherwise need to be redundancies for the seller or the outgoing contractor to redeploy people to avoid triggering that redundancy indemnity. And in fact, redeployment is usually, or quite often, a requirement of an unexpected transferring employees indemnity, that is in the mix in that indemnity. And then there might be actually a scenario where everyone has decided and agreed that there's going to be a no TUPE scenario. And that could be relevant, for example, if it's a new build and all the services are going to be newly provided. There won't be anybody to transfer, so it's genuinely not a TUPE situation. Or it could be that there are new services being provided as part of a portfolio of services. So, for example, there could be a multi-tenancy building, and there's going to be, for the first time, a restaurant for all the tenants to use, and that's genuinely new services, and therefore no TUPE.
Great, thank you very much, Jane. And now we're looking at what happens at the other end of the deal. Well, in a service provision change, there will come a point when those services will end for some reason. And Rebecca's going to look at the issues to consider on termination or exit arrangements under TUPE.
Yes, so as Siobhan said, there can be a situation where TUPE is going to apply when the agreement ends, and it's important to think about that at the outset so that you've contracted for it appropriately. So, for example, if there's a 3-year cleaning contract in place and there are employees that transfer on the commencement of that arrangement, it's also important to think ahead about what's going to happen at the end of the contract, starting with what the contractor is likely to be asked to sign up to by its client. So these are the obligations we find on the contractor that the client asks them to agree to. And firstly, information about assigned employees and their terms and conditions, thinking about what's got to be provided, how often, and when that's going to happen. And it's very common to see a requirement for the contractor to provide employee information during the term of the agreement, either on request or perhaps on an annual basis, but also specifically within a fixed period before the expiry of the contract. So quite often we see there's an obligation for employee information to be provided either 6 or 3 months before the contract expires, and also once notice has been given on the contract. So it's common to see a provision that requires employee information to be provided within, say, 7 days of that notice having been given. And that's important for the client because the client can then use that information to retender the services. So anybody who's bidding for the contract knows how many employees are going to come across, and they know how much they're going to cost. So they can factor all of that into their tender pricing for the services. And then secondly, it's common to see a set of what we call anti-sabotage provisions. And those are clauses which usually kick in the similar sort of time frame for employee information being provided at the end of the contract. So it might be that they're implied as soon as notice is given. It might be that they're in place for the last 6 months of the contract. And what those are essentially are a set of clauses that restrict what the contractor can do in the period leading up to termination of the contract. So, for example, the contractor can't redeploy its best people away from the services, and it can't assign its underperforming employees. I think, as Jane mentioned earlier, it can't suddenly increase the number of employees that are on the contract so that they will then end up transferring off under TUPE to the new employer. And as well as the obligations and restrictions that the contractor will usually be expected to agree, we tend to find various indemnities that they're asked to sign up to. And these are mainly intended to address the fact that TUPE will transfer the employees and any associated liability to a new contractor after the contract terminates. And they serve to make sure that the contractor remains responsible for what's effectively happened on its watch. So while it's been the employer of the individuals and any liability has incurred, then it remains responsible for the cost of that. And also, if there's any liability that is due to the acts or omissions of that contractor, then again, we find indemnities in place to make sure that the contractor remains responsible. And it's usual for those indemnities to be given both in favour of the client for whom the service is being carried out, but also in favour of the new contractor. And the reason for that is that TUPE will transfer the liability to the new contractor if there's a new contractor being brought in, and if the the indemnities are given in favour of the new contractor, it's preferable for the client, who can then invite the new contractor to enforce those indemnities directly. So the standard suite of indemnities that we tend to see will usually cover the points on the slide. So failure to inform and consult on termination of the contract, employee liabilities that have arisen during the term of the contract, failure to provide accurate employee information again, to cover unexpected transferring employees on termination. So if the contractor has provided the list of employees and the information, but then there are other individuals that claim to transfer, then we'd expect an indemnity to cover that. And also any failure to cooperate to achieve a smooth transfer if that sort of obligation is found in the contract. So that's what we'd expect to see from the contractor side. Moving on to look at what the contractor will be usually expect to receive from its client, we have a lighter set of provisions on termination, which is reflective of the fact that TUPE transfers liability away from the contractor for the most part, so the contractor has less of a need to obtain indemnity protection to cover it. And the provisions that we would usually expect to see are set out on the slide, and that would cover failure to provide measures information by the new employer. It would cover employment or dismissal of the employees following termination. So once the employees have transferred off to the new employer or the new contractor, anything that they do after the transfer, we would expect an indemnity in the favour of the contractor. It's actually not strictly necessary for the contractor to have that indemnity, because of what TUPE will do is to transfer the liability anyway. But it is something that we see commonly included, and it's useful for a contractor to protect itself against misconceived claims. So if an employee just fires its claim at anybody who is been involved with in recent period, then the contractor can find itself on the hook there. And finally, protection from claims under regulations 4.9 and 4.11, which again Jane spoke about earlier, the sort of constructive dismissal style claims which arise from plans or proposals of the new contractor, but for which the current employer could have liability. We normally expect to see an indemnity making sure that it's got cover for those matters.
That's great, thank you so much. And we've now reached the point where we're going to pull together the practical aspects of everything we've talked about. So we've taken a look at what TUPE is, what it does, how it commonly applies in a variety of real estate scenarios, and how the parties can contract for it. And we'll finish with some helpful hints and tips to bring all of that together for you. Over to Rebecca.
Well, thanks, Siobhan. So, in summary, due to the nature of real estate transactions, with employees often lurking under subcontract arrangements, we find it's very common for pockets of employees to come to light at the last minute. Thanks, Siobhan. So, in summary, due to the nature of real estate transactions, with employees often lurking under subcontract arrangements, we find it's very common for pockets of employees to come to light at the last minute. Taking advice and thinking about TUPE early on can minimise that risk. So once due diligence has been carried out and employees identified, then the parties can identify any mismatch between what they want to achieve and what will happen under TUPE. We call that forewarned and forearmed, and in that situation, a party is likely to negotiate a better outcome for itself the earlier it's thought about these issues and got its cards on the table. So a buyer who has been clear from the outset that it wants to be fully indemnified against a TUPE risk will more likely obtain that protection than one who's identified an issue late in the day. And conversely, a seller who's been clear in CPSE inquiries that there are employees in scope to transfer is going to be in a stronger position to hold firm on that than one who has identified employees late on in the day. And when we're talking about the need to always consider TUPE, remember it can apply to the whole range of real estate scenarios. So if you are involved in any of the following, then do take a moment to run through a quick TUPE checklist at the outset. So ask what employees are working at this site, who employs them, and how will their employment be impacted by the transaction. And we've got a quick summary on the slide there of all of the sorts of transactions where TUPE might be an issue. So it could apply to transactions involving a seller or a buyer, leaseholders, tenants, property managers or subcontractors, any of those people and in any of these types of scenarios. So where there's a sale of a property, a grant, assignment or termination of a lease, or the appointment or change in property manager and subcontractor. So whenever a party finds itself in one of those scenarios, just run through that quick TUPE checklist early on. And finally, be prepared. So review service and maintenance contracts to understand what they say about employees. Make sure there's sufficient TUPE protection if those agreements are going to be assigned. Have a think about what additional obligations arise under the contracts. Is there an obligation to provide employee information or any restrictions to be aware of? Check what apportionment of employee liabilities is provided for. So if TUPE, having done that TUPE analysis, if TUPE doesn't have the desired outcome, think about whether settlement agreements can be used to deal with employee terminations, and that can help to provide commercial certainty and be clear about the costs. And bear in mind that no two scenarios are the same. The fact that we've looked at so many scenarios where TUPE can arise in a real estate scenario just goes to show that it really is very diverse. And we often find that there are no two scenarios that are the same. And finally, the key point to take away is that lack of preparation can result in more concessions. So the earlier you think about TUPE, know where the people are and what the contracting position is likely to be, then the better commercial outcome is likely to be negotiated for a party.
Thank you very much, Rebecca, for that very strong summary. And that brings us to the end of our session today. Just leaves me to say thank you to you for joining us, and of course thank you to Jane and Rebecca for giving us all those insights and practical tips on TUPE and the real life examples that you've given in a great quantity in the commercial real estate sector. The slides and transcript are available on our website, and if you have any questions on the issues raised today, please do contact Jane or Rebecca or your usual contact at Gowling WLG. Thank you.